Hello and welcome back to the Waite of the Law podcast with me, Helen Waite, and today I'm joined by my colleague Anna Woodhoo, who has recently returned to the office from maternity leave.
Yeah. No.
Welcome back, Anna.
Thank you. Back a few months now, so I'm getting back into the swing of things, so to speak.
Yeah, and it's good to have you back. So today we thought it would be interesting for people to hear some of the family law myths and why they are family law myths. And I think we both saw recently the I can't remember which publication it was, but some newspaper had published online about Tess Daly and Vernon Kay's divorce and referred to it as they were going to have a Quickie divorce, which is one of the first myths that we can sort of bust. There is no such thing as a Quickie divorce. I don't quite know where it's come from.
No, I think when we saw the headline, we sort of looked at one another and said, well, if there is one, can we find out how, didn't we?
Yeah, because we often have clients saying to us, because there's 20 weeks, isn't there? That's the big, I think a lot of clients bulk at that.
Yeah.
The fact that once you've started divorce proceedings, there is it's like a cooling off period of 20 weeks before you can progress to the next stage.
Yeah, so essentially 20 weeks from the date of the divorce being issued is when you have to wait till the conditional order. But the way I sort of look at that and explain it to clients is actually it's a really useful opportunity because it gives you that window where you can try and discuss and sort out things like finances or child arrangements, things. So it doesn't have to be wasted time, but it is time that
Absolutely.
is built in, isn't
But
it?
I think for some clients, I've had clients saying to me, well, is there any way to make it, I'd like to be divorced faster. I don't want to wait that long. And there isn't any way around it. So this media myth that there is such a thing as a Quickie divorce is just leading everybody.
Yeah, just a headline grabber.
Yeah, just leading everyone down the garden path. And I think sometimes for us it then is difficult for us to manage people's expectations because we have to say, well, that's not, there's nothing of that sort anywhere.
Yeah, and I tend to say, with fair wind in your sails, it's likely to be a 6-month process.
Yeah.
You're not having to do too much during that, but it has to be progressed and there are timeframes that we have to work to, and really 6 months is about as quick as it gets.
Yeah. I wonder if when they say Quickie divorce, what they mean is an amicable divorce, and they're talking about resolving the finances amicably, because obviously if you resolve the finances amicably, it's likely to be a lot quicker than if you have to make an application to the courts and you're waiting for court hearings. So I do wonder if that's actually what the media mean, but obviously it's not. It doesn't make any sense.
No.
So that's our first myth that we've busted, if that's the right way to say it. And then in terms of the reasons for divorce, I think another myth is that you have to give an example of somebody's behaviour, so adultery or unreasonable behaviour.
Yeah, so until April 2022, I believe it was, that's exactly what you had to do. You either had to find examples of unreasonable behaviour or cite adultery, or you were otherwise having to wait for 2 years since you'd been separated before you could progress things. But as I say, April 2022, the introduction of a no-fault divorce system now means that actually any finding of fault has been extinguished and you're purely applying for divorce on the basis that a marriage has broken down, which is helpful. You're not at the very outset having to find these reasons and argue amongst yourselves as to who's in the wrong, and just has the effect of setting things off on the wrong footing, doesn't it, really?
Yeah, I think I would say we've all noticed, haven't we, as family lawyers, how much better it is not to have to start the process with setting out allegations about somebody else's behaviour. I think it makes such a big difference that it's just that the marriage has broken down. Irretrievably, that's it.
Yeah, no, I completely agree. The amount of time historically that had to be spent just agreeing particulars of unreasonable behaviour and going back and forth as to who had done what before you'd even really got anything up and running, and it just set things off on that sort of sour note at the start.
Absolutely, and it's a lot cheaper because people can do it themselves. And where we would be involved in drafting those unreasonable behaviour petitions and them going backwards and forwards, we don't need to be involved now. So it's much better for anybody in that position.
Even now, people being able to apply jointly.
Yeah.
We've come a long way from that sort of pre-April 2022 stage.
Yeah. Common law spouse.
Does it exist? No. I know a lot of people come to us with this phrase that they've heard, and tend to be unmarried couples trying to equate themselves and put them in the position of somebody that has been married because they've been together for X number of years, but and therefore does that entitle them to sort of similar claims to people who have been married and are divorcing? And unfortunately, it doesn't, does it? So.
And again, I think it's still something that the media perpetuates. I've still seen it or heard it on programmes where people say, they refer to the other party as common law spouse. And I think some people rely on that. And that, and again, it's something that they come to see us and then we have to say, sorry, it doesn't exist.
Yeah.
Prenups aren't worth the paper they're written on.
Oh dear. Well, we wouldn't have a job if that was the case some of the times, would it? No, provided you're following guidelines that the court have set quite clearly about how they should be prepared, when they should be prepared, they are something that a court will take into account and potentially give considerable weight to or ultimately uphold. So yes, they're not automatically legally binding. The family court can still make decisions, they still have discretion, but as I tell lots of people who I see and talk to about prenuptial agreements, would you rather have something that, if prepared properly, can really carry some weight and have a real influence on the outcome, or is it not worth the paper it's written on? But I would say that's only often the case if you don't follow these guidelines, and it's a one-page document signed on the night of the wedding where nobody's had legal advice or on the back of a napkin, whatever it may be.
Yeah, and I think we've seen over the last however many years in practice how much more persuasive they are now to judges. And I think even more so where you're trying to distinguish between what is matrimonial assets and non-matrimonial. Things like inheritance, where parties are saying, well, that's inherited from my parents and I don't see that should be split between us on divorce. I think prenuptial agreements are really coming into their own in that sense as well, because they make that very clear distinction, which you don't have otherwise.
No, definitely. And I think that they're always at the forefront of discussion, or the current government consultations looking at prenuptial agreements again and qualifying prenuptial agreements, should they be made binding? It's a real talking point, and I do think they are becoming more popular in lots of different circumstances, whether it's people starting out a marriage or people in a second marriage. They definitely seem to be on the rise.
And the other myth linked to prenuptial agreements is that they're only for the wealthy.
Definitely not, I would say. I think, of course, it may well be the case that you've already got lots of assets and you want to have some say between you and agree between you how that will be divided. But there are plenty of other people who either just want the certainty at the outset of how they want to structure their finances and deal with those, or they're anticipating gifts from family members, inheritances, they're a shareholder in a family business. It doesn't have to be that they are currently wealthy, but they want to have that say and plan for the future and decide how they want to structure things. So,
and I think my experience is that often if it's a younger couple getting married, then they may have been encouraged by parents to consider a prenuptial agreement, because in the future those parents are thinking about the family assets that will be coming to them via inheritance or gifts. And when it's potentially a couple at a later stage of their life who maybe have got grown-up children, it's not unusual for the grown-up children to be encouraging that parent to get a prenuptial agreement.
No, absolutely. People all have their different motivations, don't they? And it often depends on what are the circumstances of those people at that time and looking into the future. But it's definitely not a one thing fits all.
Yeah.
And I think
or just for the wealthy.
Yeah, absolutely.
And then another one that I think I've seen on various Facebook groups, and it's perpetuated, again, it's so many people say, oh, you can take your child out of the country without the other parent's consent. You don't need consent to take your child abroad. And I see that written on social media so often by people. Is that true?
Right. Everyone's got their own experience, don't they? And this is what I did, or this is what my neighbour did, or but no, generally, if you're taking a child out of the country, it's not the case that you can just go. You do need consent from the other parent or somebody with parental responsibility to be able to do that. If you've got a child arrangements order providing for a child to live with you, it may be that you can travel abroad for, I think it's up to 28 days without consent. But, even in those circumstances, if within those 28 days, the child is due to be spending time with the other parent, well, then it impacts that. And so you're having to have those discussions and obtain consent or reach an agreement to change those arrangements anyway.
And I think most people don't understand that it's actually a criminal offence to take a child out of the country without the other parent with parental responsibilities consent or a court order. It's not just the civil side of it, but there can be criminal implications.
Well, it's potential child abduction, isn't it, if you do go. So, I think we tend to always say to people, trying to plan for these things and prepare for that up front and in advance, because you don't want to be a week or two before you're supposed to fly off on your summer holiday to somewhere and you're scrabbling around because somebody doesn't consent now, and you're in a pretty difficult situation. So,
and also some countries require something in writing from the other parent who's not travelling with the child. I think it's Canada and possibly America, definitely Canada, that requires an affidavit. It's not just a letter, they want actually a document, a legal document that's been signed to say that you can travel with the child without the other parent.
I think it's always sensible to check what the requirements of your destination are, and I tend to say to people, if there's a question or a potential issue over travel, sometimes having a copy of the birth certificate or the actual birth certificate can be helpful. If you've got a child arrangements order, carrying whatever documentation you need, but that might be helpful in the event there is an issue, again, you might as well be prepared.
And I think just from all of these different scenarios, the moral of the story is don't believe what you read on social media. If you're not sure, it's worth getting some advice from a family lawyer, and don't listen to what other people say that might have been their experience, because it doesn't necessarily mean it's a legal experience.
And I think that's the thing, isn't it? Family law is often so fact and case specific. What fits one family and person won't necessarily translate to another, and so you can't just so easily rely on this applied to somebody and therefore will apply to me. So I completely agree. Always making sure that you've checked, you've taken the advice that you need, and preparing early for these things, not leaving it till the last minute.
Thank you for listening, and we'll see you on the next episode.